Welcome everyone, this is Amer from UCounsel. Today we will talk about civil actions in Ontario. These are the court actions that you commence in the Superior Court of Justice in Ontario, and we will talk about 6 basic steps that are commonly taken in the proceedings of these civil actions. The lecture is really designed for people who have no legal background so they can understand the fundamental steps in a civil action in Ontario. And as always, we will commence with the disclaimer that this course is not legal advice, so if you have any specific questions about your issues, you must contact a lawyer or a paralegal. The civil actions in Ontario are governed by specific legislation, and there are 2 legislation that you want to keep in mind. Those are your starting point if you are going to research the procedure for a civil action in Ontario. The larger legislation is the Courts of Justice Act, and underneath that are the rules of civil procedure. These are regulations under the Courts of Justice Act. Both of these legislation are available online. You can go on Google and type in rules of civil procedure. CanLII is one website, but they're also available on the government website, and you can check those out. I want to show you a few things about the rules of civil procedure so you can understand the layout a bit better. Let's scroll down to the table of content, and you will notice that there are about total of 77 rules, and each rules have a number of sections, and so there are a lot of, in other words, there are a lot of rules that you need to keep in mind depending upon the circumstances of your court action. The way these rules are laid out, they are in different parts, or you may call them chapters, and they start from general matters, parties and joinder, commencement of proceedings, so on and so forth. And what I want you to pay attention at this stage is that unfortunately the rules are not laid out in a way that a person who is not a lawyer or not a paralegal can easily decipher. And what I mean by this is that if you want to understand that what is the process, what are the steps to commence a court action, it doesn't lay out the rules in that manner. So you don't see here chapter number 1, commencement of court action, and then you have to take following steps. It is laid out in somewhat of a sequential manner, but not necessarily with people with no legal background in mind. So what I've done in this lecture is to summarize some of the rules, take them out of their sequence in the rules, and then explain to you the process. So each section, each step that I'll be talking about, it may be referring to a different chapter, but the overall concept is that you have an overview of how these court actions are commenced and how these court actions are concluded in the civil action in Ontario. Let's begin with the 6 steps. Step number 1 is obviously pleadings, and I'll explain what that is. Step number 2 is affidavit of documents. Step number 3 is discovery process. Step number 4 is mediation. Step number 5, pretrial. And the last and the final step is the trial. What are pleadings? A pleading are the documents in which each party lays out their version of facts about the issue. So a party that commences a court action, they will start their court action by filing and serving a document which is called a statement of claim. And a statement of claim essentially is, if you are the claimant, if you are the plaintiff, if you are the party who is commencing this court action, then statement of claim has 2 components. What is it that you are asking the court to do for you? Are you asking for money? Are you asking for return of property? What is it that you want the court to do? And then the second component is, what are the facts that you are relying on? What is your story? Why the court should give you what you're asking? So those 2 elements are the fundamental elements of a statement of claim. What is it you're asking, and why are you asking this? What is your story? In response, the defendant will serve and file what's called a statement of defense. And this statement of defense will contain the defendant's story. What they are asking the court to do. Are they asking the court to dismiss the plaintiff's claim, to throw it out, to reject it? And what is their version of the story? Why do they believe that the court should not award the plaintiff, the claimant, what he or she is asking. There are additional kinds of pleadings, and in some circumstances the plaintiff may again file a reply to the statement of defense, and there are specific circumstances in which a reply can be filed and must be filed. And when we get to each element of the pleadings in different lectures, I will explain to you when a reply is served and filed. Pleadings are also counterclaims. So if the defendant has a claim against the plaintiff, then the defendant can issue what's called a counterclaim and explain or ask the court what is it that they want the court to award against the plaintiff. And one more kind of pleading is third-party claim. In this situation, if a claimant or a plaintiff has sued the defendant and defendant believes that it's not them who are responsible for those monies or for those damages, but it's a third party who should pay for those damages because they are the ones responsible, and they want to bring that third party into that court action, then they will bring what's called a third party claim, and that's how the third party claim will be issued. So pleadings is really the first step in which all the parties are laying out their position, their facts for the court, for the judge, and then explaining their side of the story. Pleadings are very brief. Only the facts are relied on. There's no evidence that is provided at this stage. Next step is the affidavit of documents, which is really the evidentiary part of your court action. Through affidavit of documents, each party provides whatever evidence they have in relation to the claim. If you are the claimant, if you are the plaintiff, and you have certain evidence, certain documents that you need to rely on, then you must provide copies of those documents to the defendant. This is an important point to understand. There's something called a trial by ambush. And trial by ambush, what that means is that one party does not know what is the evidence against it, and all of a sudden the other party shows up with that evidence at the eve of trial, during the trial, and then it destroys the other party's case, and then they can walk out freely. Most of the time you see these kind of tactics in criminal cases where this is allowed for the defendant. So if you watch Law and Order or similar cases, you can see that at some point the accused walks in, or accused lawyer walks in with a witness who nobody knew who that person was, or walks in with a piece of evidence that is so damaging that it can destroy the Crown's case, the prosecutor's case. And that's okay in criminal cases, but in civil cases there is no trial by ambush in Canada or any part of the common law world. So what this means is that each party is entitled to know exactly what evidence the other party has against them and have the opportunity to review that evidence, to inspect it much before trial. So there's no surprise attack in trials in civil cases. I want to explain that documents is a very expansive term. These are not just the paper documents. Documents include every single tangible piece of evidence that may exist. So these could be electronic documents, emails, text messages, cell phone records, metadata for your documents, photographs, videos, audio recordings, paper documents. So every imaginable thing that is tangible is document, and if it's relevant, it needs to be, or it must be produced for that court action. The document is defined in the Rules of Civil Procedure. Section 1.03 sub 1 provides or contains the definition of documents, which I had explained to you. So each party, on completion of the pleadings, has to serve the other party with copies of their affidavit of documents, which contain all the evidence that they have against the other party. The next step is the discovery process. Once the affidavit of documents are exchanged, each party is allowed to see if there is any further evidence that the other side has in its possession, and they do that through the process called discovery process. So you are discovering more evidence from the other side. One way it is done is through examinations for discovery, and discovery is defined also in section 1.03 sub 1 of the Rules of Civil Procedure. So examinations for discovery is you call upon the other party to attend examinations for discovery, and you are sitting in front of a court reporter. The court reporter records all of the questions that you ask. They are audio recorded, they are transcribed in writing, and the other party has to respond to the questions that you're asking. The questions are really to explore if there's any more evidence that you need to figure out that the other side may have. Sometimes when you review the other side's affidavit of documents, you may realize that the documents are referring to a meeting and there are no minutes of that meeting provided to you, so you may want to explore whether there were such minutes of the meeting and whether those minutes are discoverable or not. There could be additional witnesses that you may discover through the discovery process, and you want to make sure that those witnesses attend at trial. So discovery process is really an opportunity for each party to explore whether there is more evidence that needs to be presented, that needs to be obtained prior to trial. Because remember, when the trial begins, then you don't have or rarely have an opportunity to adjourn the trial on the basis that you have discovered new evidence that is not available at this time, and so you need to adjourn your trial, go get that evidence, and then come back. When the trial begins, usually you are expected to have done your homework, produce all of the evidence that you need, and then proceed with the trial up to its completion. So that's why the discovery process is generally the most important step in a civil action. Once the discovery process is complete, or even sometimes before the discovery process, parties go to mediation to see if the matter could be settled. Now, depending upon which region, which municipality your case is, your court action is in Ontario, you may have mandatory mediation, and in some you don't have mandatory mediation. In Toronto, the mediation is mandatory for all court actions. So what this means is that both parties, or all of the parties, have to agree to a mediator who has to attend a mediation session and explore whether this court action could be settled without going to trial. And I can tell you from experience in employment law cases that the majority of wrongful dismissal cases, over 90–95% of the wrongful dismissal cases, get settled at mediation stage and don't even go to trial. So if you want to know whether the mediation is mandatory in your specific region, you must check the rules of civil procedure and practice directions to figure out whether you are required to conduct a mediation. And if you're not required to conduct a mandatory mediation, you may still want to explore with the other side whether it's a good idea to go and attend mediation. If the matter doesn't settle at mediation, you can proceed to pretrial. Pretrial is really another attempt now in front of a judge to see if this matter could be settled. So when a pretrial is arranged, it's now arranged in front of a master or a judge, and the judge will first of all try to see if the parties are willing to resolve that matter, and the judge will try to help those parties to come to a resolution. If the parties are still not able to resolve their case, then the judge will try to narrow down the issues for trial so that the trial judge knows what are the legal issues that he or she has to decide at trial, and then narrow those issues down for the trial. And finally, the judge will figure out how many witnesses each side has, how many days it will take to complete the trial, and then schedule the trial dates. Final step is the trial. This is the step where you are presenting your case, all of its evidence, either before a judge or in front of a jury. And the judge or the jury will ultimately decide who wins the case and who loses. At the end of the trial, there are always winners and there are always people who lose. And if you don't want to be in that position, that you really want to explore prior to the trial whether this matter could be settled. Few things that you want to keep in mind is that if you are in a court action, or you want to commence a court action, or you're defending a court action in Ontario, you want to read the rules of civil procedure and the practice direction to understand what steps you have to take. You also want to keep in mind that for each step, for each document that you have to file or serve, there are forms for that step, and then those forms are also available online. You can go to Google and type in rules of civil procedure forms. and these forms are all available online. And you will notice that these forms are numbered, and the way they are numbered is usually if it's let's see, this is the number 4A. It's titled General Headings of Documents and Actions. 4A, this document relates to Rule 4 of the Rules of Civil Procedure. And if you scroll down, there are all these documents are numbered, and they are related to the specific rule that they are referring to. And so you can find out these documents. You can open them in the Microsoft Word or in PDF, and you can complete those documents. And these are the ones that you file. You want to remember that even though you may have commenced a court action or you are defending a court action, the court action can be settled at any time. So you may have been served with a statement of claim and you believe that the matter could be settled by talking to the plaintiff or to the applicant or to the pleading party. Then you can have that resolution. You can go to a mediation, you can have a third party help you with the settlement, and you can settle it. There are cases that settle at the eve of trial. There are cases that settle during trial. As long as the trial is not completed, you have that opportunity. Even sometimes before the judgment, you can actually settle the case and then allow the court to dismiss the court action without getting a judgment. So settlement can occur at any time, at any stage. It really requires all parties to agree to a settlement and then settle the case. Last thing I want you to keep in mind are the legal costs. There was a study that came out a few years ago in Toronto which indicated that a 3-day trial in Toronto, from the time it is commenced through the statement of claim to the time the trial is completed, a 3-day trial cost upward of $50,000. So those are sort of the legal costs that are present in our system, which are quite high, and it's one of the factors that you want to keep in mind when you are deciding, when you're taking your case all the way to trial, whether in a cost-benefit analysis it makes sense to fight the cases all the way to trial. And not to ignore that the resolution through trial takes a long time. The courts are overwhelmed by so many civil cases that it takes quite some time to get to trial stage. Hopefully this lecture explains to you the basic steps of civil action in Ontario, and then what we'll do in the future lectures is we will cover some of the important rules in each lecture, explain their application, explain what do they mean, how do you apply those rules in your own circumstances, and then as we move forward we'll try to decipher, unravel the mysteries of rules of civil procedure. If you have any questions, please contact us, send us an email, or post your comments, and we'll be happy to address those. And if there are any specific rules or questions relating to any specific rules that you may have in your mind, by all means contact us, and we'll keep adding those in our future lectures. Thank you for watching.